Hi, Rachel.
Hello, how are you doing, Katie? You all right?
Thank you. How are you?
All good, thank you. All good. I thought
Lovely.
you disappeared on me for a moment. It looked like I'd admitted you, and then you disappeared, and then you came back. What a relief.
Oh, bless you. Well, I'm here now, so that's the main thing.
Absolutely. You didn't have to have the recording of me looking really confused, wondering where. where's-
Where I gone?
Oh, thank you so
Oh,
much for joining me tonight.
it's all
Uh,
right.
we've had so many people ask about AppClose since they've
Yeah.
introduced um, you know, their way of making money, which is, completely understandable.
Uh-huh.
But obviously, it's named in so many different people's orders and
Yeah.
things like that. So it's had a big impact on people, and it's another way that people who don't want to be, you know, collaborative are able
Yeah.
to put some barriers in the way, and I'll
Exactly.
as nicely as I possibly can.
Hmm.
So have we've sent over the form with all the questions.
Yeah.
So that's absolutely amazing. Do you want me to read any out, or how would you prefer me to do this today?
So I've had a look at over everyone's questions. So some really, really good questions
Yeah,
because it is a complete minefield when you've got a court order that you want to comply with, and then immediately that resource is removed from you
yeah,
for whatever reason. It can be quite alarming because you want to do the best to try and comply with it. So I've been through everybody's questions. And I've got them all in front of me just with some draft advice. So perhaps we go question by question and just do
let's do
question one on the spreadsheet, and then we can go from there. Okay.
Oh, amazing. So the first question was all about obviously communicating with the co-parent as soon as AppClose advised the charges. Made it clear use of the app was important for carrying on with their co-parenting relationship, and that it was included on the court order.
Yeah.
Co-parents then said they'll look at alternative apps. That person's then chased and on at least two occasions sent over the blog, done everything they possibly can to get that other co-parent to move forward, and they've kind of blocked it. So they're not complying really.
Yeah.
Now, now Access has stopped. He's emailing me, and I think that's the issue there, that they're using email and they're using sort of WhatsApp and all of the ways that they were communicating previously
Mhm.
to, overstep boundaries and stuff like that. So, what advice have you got for that person?
So in terms of when we're looking at a co-parent overstepping boundaries that aren't necessarily in the court order, which is the crux of what's happening here, we are looking at trying to get that co-parent to comply with the order insofar as possible. So if the order specifically names AppClose as the only method of communication, that order should be followed. However, I understand that we're in a position where, we're looking at additional charges where it wasn't perhaps considered when you were entering into the court order. So at the moment, we're looking at one parent wanting to continue app contact only, and then another parent moving it over to email, which is obviously not appropriate in the circumstances, because email, as I'm sure we all know, can give the other parent the opportunity to sort of perhaps have a less managed format of communication, and that can then cause miscommunication issues, or perhaps there's less strict timeframes around answering that there may be within a parent.
Boundaries, isn't it? Yeah,
Yeah, exactly. And it makes it that much more difficult to enforce. So the baseline advice is that court orders must be followed.
yeah,
Switching to email without agreement is not acceptable, because it's not a variation to the order, and a court are very unlikely to accept. They will just be asking the question as to why another app wasn't used in those circumstances. And in terms of it not being a priority to him, well, that's quite an unhelpful way of viewing things, because I think it needs to be made clear that that is the method of which the court has ordered you to have contact.
yeah.
The only method that you should be having contact is through an application. And in my view, I disagree with that belief that a judge will rule using free email as fine. I would suggest that there's a robust communication sent to him via AppClose or via email in the interim, saying I will no longer be communicating with you via email because it's not the court-ordered method of communication. Here is 2 or 3 parenting apps that I proposed. Failure to comply with this and download the app, I'm going to have to seek further legal advice and consider an application to the court to vary or enforce the order. Because if it's written into the order, the other parent isn't complying, that non-compliance does need to be drawn to the court's attention if it's a continued pattern, especially if email is being used to have sort of inappropriate communications in any way. It just gives you more grounds to say the other parent is not complying with the terms of the order, and I need the court to step in. So I would suggest that you carefully document all of the communications that you're having with your ex, and just really emphasize that the app-based communication supports not only your co-parenting relationship, but also your child's welfare, because it reduces the conflict between you both. And I would just suggest putting it out there in sort of a more formally worded email and just saying, look, I've sought some advice. This is the position. We need to be following the order. I know that AppClose was the named application in the order, but that's clearly not possible for either of us at the moment. Therefore, I suggest the 2 parenting apps that you've suggested. Can you please come back to me within 2 weeks about this, so I can sign us both up or send him the link, or whichever way that particular app deals with things. And then once that's sort of been dealt with by the other party, then we can consider sort of next steps, and they may well be an enforcement of the order or a variation to name an alternative app.
And I suppose being aware that next time, in whatever's written into the order, there's scope for things like this happening again, isn't there? So if you have it worded an app or similar, however it is that you think that would protect you most in the future. I noticed on that one, it would be the person who was trying to comply would then have to take the person back to court. Could you word it in such a way in that initial letter saying, if you really feel that the judge would choose free email, then please take it back so we can vary the court order? So it sounds like being a bit friendlier, but actually you're sort of saying, well, you pay for the
application. So when we're looking at a variation, I think if I was looking at it in circumstances like that, I wouldn't ever want to put my client in a space where we were on the back foot with a communication such as that. I mean, if the other parent felt very strongly in their opinion that the judge would be completely fine with it, then of course you're more than welcome to invite them to make their own application in relation to it. In my experience, when we're trying to sort of compel parties to comply with the order, essentially, I think we're often the ones in the position where we're having to take the bull by the horns and really address it and say, look, these are my options. I don't want to do it. I'd rather just have a normal conciliatory co-parenting relationship with you through the app, like we agreed. But if you are in a position where it's going back for a variation, or or you're applying for enforcement of the existing terms, a reword is likely appropriate if AppClose is named specifically. I just tend to word it when I'm drafting orders. It's the agreed application that's currently being used. So the parties shall use X application, and that can be varied by agreement, and that gives you the scope. But in my experience, lots of people draft orders in lots of different ways, so that might not be the wording that you're working with. So
it's tricky, isn't it? And trying to word things in a way that keeps that not flexibility in the true sense, but sort of that protection, I suppose, really, isn't it? That so that it's not open to manipulation later on, but also can protect you a little bit. It's the minefield. Let's be fair, it's a minefield.
And these things do happen. AppClose is a private company, and they've clearly made it the change to make a little bit of extra money, but it is a case that a lot of parties won't be in the position to meet those costs, and that wasn't anticipated when they agreed to the terms of the order. So that's why variations to court orders exist. But I do appreciate, when you're weighing up the costs of a variation application, especially if you want legal representation to do so, versus the costs of perhaps just paying for AppClose.
Yeah,
those two factors might not, weigh up in favour of the variation application. But
yeah, absolutely. Funnily enough, one of our members actually got in touch with AppClose, and they've now agreed that the one parent can pay for both of the both parties' sort of fees, and it can be done by you don't have to go via the other person. You're just able to nominate and pay, which actually is that's come from weighing up, is it worth going back to court, the cost of that, and all of the mental load and the emotional load and all of those things that come with going to court. There's discreetly paying and just going, oh look, we've had it waived.
Yes, we've sorted it, and that's in my experience, a lot of co-parents do take that approach, and especially if they're dealing with a high conflict ex-partner that's perhaps going to use a little, what we would perhaps consider a little change to manipulate the circumstances, then sometimes it's the path of least resistance to just say, right, so I'll make payment of both of ours just so we can use it going forward. So there's no wrong way to deal with this. There's sort of a tiered level of ways dependent on what you're dealing with,
and your resources as well, because money and time and all of those are different resources that people put different weighting on and what they have available to them. So it's absolutely what suits A does not necessarily suit B, and it's kind of weighing that up and making it that conscious decision of what you'd rather, I suppose, isn't it?
And I think that takes us actually quite neatly onto question 2, looking at it in terms of this parent has decided to pay for both parties to have access. But the other parties, you've been using email to communicate inappropriately, and now they're still getting emails despite AppClose being made essentially free for both parties by one party paying. So I think this person's asked what can they do if he doesn't continue to use the app and continues to email. So in terms of what my advice to them would be is I would say just keep records of all communications that take place outside of AppClose, and just get your evidential base there. And also I would center your communication via AppClose only. Do not respond to anything via email. Keep it all within app. I would also suggest, as with the previous question, that you send out a polite written reminder that just says to the other co-parent, obviously via AppClose, I would suggest that this is what it says in the court order. The communications need to be undertaken via the app, not via email. And I would then sort of withdraw communication entirely via email and just focus it through the app after reminding the other co-parent. If they continue to do so, I would suggest attending mediation about it, because it is a very narrow issue. And I would suggest proposing that to the other parent, just so you've got that to fall back on. So you can say, I've tried to deal with this in a conciliatory manner. Inappropriate communications have continued, and then you're sort of protecting yourself against a further breakdown in communication. Because what I find is if they're continuing to sort of breach the order knowingly, and send written communications via email, it seems like quite a small point, but then it can be quite emotional.
It's that boundary constantly being pushed and pushed and pushed, and where does it end, and at what point do you decide, oh, that's too far, and then
exactly
the next surprise that you've said that's too far. So do it at the first stage to protect your peace,
exactly. And in my view, especially if you've been to court previously, a lot of parents will sort of get the idea as to why another parent is suggesting mediation. It's very much okay, I cannot deal with this personally with you anymore. We need to be moving this out of this sphere, so we can communicate effectively, rather than, you know, having the other parent consistently breaching boundaries and then moving that communication into a sphere where the other parent is not comfortable. You immediately feel on the back foot. Your boundaries are being broken, and you know, even though you've tried to enforce them, it is not perhaps being listened to, and the other parent might see that as quite a small point, but it's not in terms of the emotional toll that it takes. So that would be what I would suggest in the first instance, is sort of propose, if it does continue, say, look, I've brought it to your attention that this is an issue, and keep it very polite and say, I brought it to your attention, I've noticed that you've still been emailing me. You will not be provided a response to any of your queries via email. If you'd like to address this further, please apply to mediation. Or if you want, if you're more comfortable moving it yourself into that sphere, then you can propose that at that point as well, because then that's just the precursor to moving those discussions into a bit of a safer space.
Yeah, and of course you run the risk, don't you, where if you start doing things that are not outlined in the original order, it looks like then you're complying with the new change, and it might not be something that you want, but the other parent would actually say to the courts at some point, well, we've been doing it like this for 6 months, so what's the problem now? And actually it's harder to retrospectively kind of go back and go, oh, no, I never wanted that. It's almost like those boundaries really have to be enforced, don't they? It's so tricky.
It is, because you don't know when you're trying to be conciliatory and calm about the whole thing, you're almost inadvertently creating a new status quo that the other parent can then rely on. If in the worst case scenario, you do end up with a further court application, and that's something we really don't want to be doing. So it is a case of setting and enforcing those boundaries. You have made payment for that app. You should be using it. It is in the court order. Any communications via email are not court ordered communication methods, so shouldn't be dealt with, and should be dealt with via the app. And it's hard. I know it is. It's so difficult to say, especially when you're dealing with a high conflict ex. But you've just got to set that boundary at the earliest possible point.
I agree. And it's trying to think bigger picture, isn't it? Right, I need to do this here for less pain somewhere else, and you know, that's kind of the view you need to take.
Yeah, this is it.
Always in through these. So very similar, this one. So this is another one saying, you know, stuck in limbo, co-parent is refusing to use the app because of the cost, and advise they'll look at other options but aren't offering up anything, and likely use the situation to avoid communicating via a co-parenting app going forward. What can you do?
Yeah, I wouldn't say that indefinite delay to a big decision like this is acceptable in any way, shape or form. Your co-parent can't avoid using app-based communication by indefinitely looking into options. That's not how it works. It needs to be a proactive response. And I think what's perhaps happened here is you've addressed this with your co-parent, and they've said, yes, okay, I'll deal with it. It's immediately been put on the back burner, even though it is sort of the primary source of communication between you both. So the indefinite delay aspect or the significant delay shouldn't be expected or accepted in these circumstances. So what I would suggest in the first instance is proactive proposals of solutions. So I'd go on and say one or two, and suggest one or two low cost options, or options that offer, you know, perhaps hardship payments. I know our Family Wizard is pretty okay at getting back to people, because I have seen, and I have had it reported to me, that AppClose isn't particularly good at getting back to people about, you know, sort of hardship alternatives, so that's not something that I would suggest looking into, just for mental bandwidth more than anything.
Yes.
But I have heard positive things about our Family Wizard, and that their lower cost and hardship packages can be quite beneficial to parents. So that might be worth looking into.
Yeah.
I know that there are a couple of free alternatives on the market at the moment. In terms of their usability, I can't comment because I've always suggested AppClose just because of the quality of it. But in terms of taking the bull by the horns, I would suggest sending two or three suitable co-parenting apps and say, like, can you just let me know within the next week or so whether you're in agreement to either of these, even include website links, just lay it all out for them so they've got it and they can't say anything otherwise. If you feel it's necessary and you think the other parent is going to be obstructive, I'd include in that sort of proposed solution message that it should be really focused on the best interests of the child. If they can't sort of comply with this one small aspect of it, I think it needs to be sort of brought back to a child-focused way of dealing with it, and just say, look, it's actually in the best interests of our child for us to be communicating in a safe way. Either reconsider the position in relation to the app, or can you consider like my reasonable proposals above?
Would it be okay to say something like, these are like 2-3 options, like you said, if you don't come up with a preference or an alternative that makes sense by 14 days time, 10 days, whatever it is that you decide, we'll go with, and then just name one, because then it kind of is that sort of that non-compliance is then becomes a decision, and it's not a whole nother round of emails and things like that. Would that be acceptable? Or
in my view, I don't see any issue with that, because again, it's a proactive solution to what the other parent has raised as a problem, and I can't see any court or judge having an issue with that, because you're giving solutions to a problem that the other parent has raised, and you've just said, right, okay, you've had your time, let's just focus it in on that way. And then you've then got the remit almost to be saying, right, okay, I won't be accepting correspondence through any other means. We've been ordered to have an app. We should be having an app. And I just go back to that one paragraph in your court order where it says, and just really consider it, because court orders should be relatively easy to understand. They should be drafted in a way that neither party will be able to get around and manipulate. I know it doesn't always happen, but in terms of the way that we're looking at it, just go back to that one section and see what it is that's actually been ordered. If you've got any scope to sort of say, these are the other apps, and it just says whichever other app is reasonable, you can just go in all guns blazing really and say, right, okay, you've had your time to agree and indicate a preference. This is what I will be using, and this is where you can communicate with me going forward. I won't be accepting. And then you've given notice and you've asked for compliance, and that's all you can do. That's all you can do.
Sometimes you have to be a little bit pragmatic about and I often say with different scenarios that sometimes that lack of response is a response in its own right, isn't it? So that we're able to you word it well in the first instance, you can take their lack of response as, okay, so that means this decision, rather than it being open-ended, and then that's not to carry, isn't it? Constantly wondering if somebody's going to reply, if they've done something, but at least if at the end of that 14 days, a decision's been made, even if it's not been collaborative, it's passive. Decisions be made.
This is it, and it's showing your other co-parent and the court that you are making those decisions. You're making the difficult decisions even when the other parent is making it hard, and by doing that, you're trying to foster a more collaborative approach. You've tried, it's not been successful, but you've still sort of put that effort into making sure that communication is safe going forward. So I can't see that being problematic whatsoever. So it is just a case of being as clear and conciliatory as possible. I know it can be hard sometimes, but you've just sort of got to set out the options, give the co-parent a chance to deal with it. If they're not going to deal with it in the appropriate time frame, then you've got more scope to start making those decisions on a bit more of a unilateral basis, and then it's for them to raise issue with it, and perhaps further collaboration can be had. Or Alternatively, you've got the app in place and they
Yeah.
can start using it accordingly.
Absolutely. It's sometimes decisions just need to be made, don't they? So slightly different flip on this one now. So the next one is if your co-parent suggests use an alternative app and you're not happy with it because it doesn't feel secure, they're given examples of when it comes to recording, editing, deleting messages. And we know that deleting messages and changing what they said is a big issue, which is why WhatsApp obviously gets we move people off WhatsApp and into apps like this. What's the best approach to try and sort of refuse but do it in a way that shows the child focused and not trying to create problems in the future?
So I definitely suggest to explain your concerns clearly to the other parent, even if it's just a clear bullet pointed list, and just say this app is not going to quite cut the mustard in terms of security, text message records, or ultimately it is the welfare of your child, because if one parent's going through and deleting messages, it is not a safe communication method, and neither party can feel safe using it going forward. So I'd explain the concerns as sort of evenly as possible, not making any sort of suggestions either way as to why that app's been suggested. Just keep it very factual and say, I don't think this offers us enough security, and I don't think it's going to be the safest arena for us to communicate in relation to our child, and nor will it be in their best interests. So if you explain that to them clearly, and suggest the alternatives that you feel are going to be appropriate. So again, I'd say between 1 and 3 alternatives that you think are going to be secure enough. You don't want to sort of snow them under in information, but also you need to be making sure that the proposals offer them enough selection within what you're trying to achieve in terms of security. So once you've done that, that's discussion. If your co-parent is still not sort of engaging with those communications and attempts to agree alternative apps, I would suggest that you continue to remain open but firm with them and say, we need, and this is in the court order, we need structured and tamper-proof communication, otherwise neither of us are going to have any security. At that point, you've got sort of the option to suggest mediation, or if you feel that the other party is not going to be agreeable or open to mediation, you can then go and get your MyAM form and consider an application to vary the order, just so you've got it to go back on, because the court will be quite sympathetic to applications of this nature, in my view. I haven't seen one come through yet, but in terms of what we're dealing with, it's not as though parties have gone into an order with an understanding of what's happening, or what's going to happen with the app, agreed to the app specifically, and that's now changed. That is the case now.
Yeah,
so
that's change, isn't it? It suddenly having to pay for something that was named as free. So it's good to know that the courts are being realistic about the impact that's having on families. So that's good.
Yeah. And just a point for our South Wales based parents as well, I know that quite a lot of you are. We are under the Pathfinder scheme at the moment, so the court will aim to deal with applications as quickly as possible. So what we're seeing now is applications being dealt with in approximately 3 months. So that is something to consider as well, if perhaps you've made an application upwards of 3-4 years ago, that's now been dealt with in the old way of dealing with child arrangements applications, and you found that quite taxing. For smaller issue cases, such as a variation to the parenting app, that's just dealing with one clause of an already in place order and everything else appears to be working fine, the court may deal with that on the papers even. Once you're in those proceedings, you may not even end up at a contested hearing over that if the other parent is broadly in agreement and reports that to CAFCAS.
Yeah. Oh, that's really good to know, actually, because it is something that people worry about and don't want to relive, particularly, as you say, if it's been 3, 4, 5 years ago when they're first going through this. And, we don't want to re-traumatize people if we don't need to. I had a question about the apps. I'm not in a situation where I need to use apps, fortunately. But they're normally really clear as to their security, aren't they? So it wouldn't be something that's open to interpretation. You'd be able to know if you can edit, delete, all of those type of things, or more specifically, they would say that you can't, wouldn't they? If that was a picture of them. So look for that when you're looking for the right app for you, to make sure that you are walking into something that
I agree. Yeah. It's more difficult, I would suggest, to find a parenting app that allows you to edit things. I'm surprised this person's co-parents managed to find an app that allows editability, because in my view, that's why I've always recommended AppClose, is you've got that security and you know that the other parent won't be able to manipulate messages. And that's the primary purpose. That's why many parties go into it wanting that. So
I wonder if they found a messaging service as opposed to an app, which, obviously are very different beasts, aren't they?
and then you may even have grounds to say that that's not in the court order. We can't be using a messaging service. It needs to be a sort of out and out parenting app, more so. But that's for later. I'd suggest to keep it conciliatory at first, and just set out the options really clearly. Just saying it's not secure enough. We need to consider other options. This is what I've had a look at. Here are the website links. Have a little look. Let me know your thoughts within 14 days. And then you can consider your options from there, dependent on the reaction.
Amazing. Oh, that's really, really helpful. And then we end with a question that's actually, quite nice, relatively. So if you both agree on using an alternative app, and AppClose is court ordered, should you put in an application to change the CAO? And what are the risks if you don't, along with any charges? What's the cost going to be like for doing that if you already both agree? What they're essentially asking is, are you able to both send an email or whatever back and forth to each other to say, we agree that this is a change in the order and we'll do this moving forward because of the costs?
Yeah, so I mean, it's a very good question, actually, because what you will find is that the broad recommendation will be you should do so formally. Any changes you want to make to a child arrangements order, if you want to do it formally, it would require a C100 application for variation, and then you can indicate to the court at that stage that you're both in agreement to the order being varied on those terms. Practically, the position is very different in that you're not going to necessarily want to be paying out to make an application for variation if you both agree. So what I would suggest is, if you are in a position where you're both in agreement, I'd suggest that you get it in writing, formally. Perhaps you can both look at doing a shorter agreement that you both then sign, and just keep a log as well of the using the new app if you've agreed to vary the terms of the order, and then that variation is adopted as standard, as though it was almost a part of your original agreements in terms of the order. Then you are creating a status quo that sort of proves by pattern of conduct, really, that you're both in agreement to that decision, and then though the other party technically still has legal recourse to take it back and request enforcement of the original order, their pattern of conduct will have shown that yes, they were in agreement to varying it, especially if you're 6 months to a year down the line, you're still using the alternative app, and it will likely be extremely costly and impractical for them to take it back. So that is the primary risk that you're sort of running when you're making variations by agreement. But if there's that clear chain of evidence running from the decision being made, both parents making that decision, and then you've got the evidence back up throughout the course of a few months to a year, or however long it may be, and then the other party suddenly decides, well, okay, you've upset me today, I'm going to take it back and enforce it because we've not been adhering to the order, the court are going to have very limited patience with that.
is if you do things in the spirit in which the order was set up, both agree to it. There's the court isn't going to like you using the court as a means of control later on down the line, are they? So it sounds like they've come up with a way that works for them. It's like time and distance over. It might have been acrimonious a few years ago, and now it's less so. People have moved on, but you still got that situation where you think you feel quite protected by using the app and having a different app and just going, actually, this is the new status quo. But it's quite low level, isn't it, in terms of the CAO? It's not a big structural change. It's a move over from one thing to another. And if you're both in agreement and obviously both really compliant with it, that sounds like it can be a bit of a non-event.
I would be very surprised if the court took a sort of approach penalising one party or another for not, especially if the decision's been made on a clearly joint basis, and you've got that evidential backing where you can clearly say, right, we've made that decision on this date. If you're particularly concerned, I would suggest that you get something in writing that you both sign. If not, definitely sort of in email or text message correspondence, just in writing. So we've got that going forward, and then once that's adopted, you're right, it is in the spirit of the order. Obviously, we require parties to try and communicate as amicably as possible, because that's always going to be in the best interest of your child. So it is not only in the spirit of their sort of personalised court order, it's in the spirit of the wider Children Act generally. So the other party will have very limited legs to stand on in terms of they would need to then prove that the agreement, that the breach has had a detrimental impact on their child's welfare going forward, which will obviously be a very difficult case to run because there's likely to be no supporting evidence for that. So I tread carefully, document everything, but in terms of actual enforceability and practically, I certainly wouldn't be advising if somebody came to me and said, I've agreed 6 months ago with my co-parent to vary the use of the app. I've decided now I'm not happy with that. I want to take it back and enforce it and get them done for all these breaches. I certainly wouldn't be advising somebody to go with that course of action, because I don't think it's proportionate on a costs basis. So turn into that point finally as well. When we're looking at variation, you do have to use the C100 form because it is a variation to a Section 8 order. But in terms of representation costs, you'd probably be looking at between 1,500 to 5,000 for something like that, dependent on the level of acrimony. And that would be inclusive of the court fee, which if you wanted to represent yourself in that, because it is quite a straightforward application, you'd be looking at £263 for that. So it depends. In terms of my view, I would say it's not cost proportionate. But if you and your co-parents are very much of the view that you're both in agreement, you just want to take it back to get it rubber stamped by the court and you'll both represent yourselves, then that might be a more cost effective way to deal with it. But then you do run the risk of it depends what judge you end up in front of on the day.
Supplementary question. You mentioned about like signing something. Would solicitors not do this for you, or would they be party to it, where you maybe both went in and just got a solicitor to witness that you signed that, or would that be something that would be sort of like a halfway house that to give you a bit more surety in that you're both making that decision?
I mean, I haven't personally. I don't necessarily think it's something that you have to involve a solicitor in, to be honest, because you can sign things, you can sign agreements. It's more akin to, rather than a formal agreement by way of deed where we'd be looking at a contract, I think it's more akin to a parenting plan that we'd have in mediation, where the mediator would write it up and both parties would sign at the end. Obviously, agreements are always more persuasive to the courts when both parties have had independent legal advice. For such a minute issue, in the grand scheme of the court order. I personally think that having a short, I agree to this. We confirm that on X date we have agreed to vary. Well, I wouldn't necessarily even use vary. We have agreed to use X app going forward from this date, and then both pop a little signature on. Or even if your co-parent's being a little bit obstructive about the whole thing, just an email exchange with both of your signatures on it.
Yeah, so just a nice common sense approach to it rather than drawn out. So I suppose that's what your risk levels are, what you worry about most. So that will then be one of those ones where if you're both in agreement and you feel like you're in a trusting place with that person, then just go with it and just make sense for you and document it along the way. Oh, that's been really good. I've learned.
Thank you. That's all right. I'm always happy to help. But yeah, thank you everyone for your questions. It's hopefully it's helped, and I know it's been a bit of an uncertain time, especially when the costs changes have come out of nowhere. But nobody's alone in this. It's the whole community, isn't it? I've had multitudes of clients come through the door and think, oh my gosh, I don't want to blow this out of proportion, but this is a real issue. So if I can offer some clarity, then that's always it's always good for me. So yeah.
Oh, thank you. And have you noticed the courts put in something like this app or another, or of that sort of? Has there been any changes moving forward of the because of this?
Yeah, I think certainly when I'm in court and representing, I do like to give people the option, because these things do happen, and sometimes there is an act of God that makes the previous order unusable, and then we're back again. So in terms of the suggestions that I would make to the court, yes, I do always try to do that. But in terms of the court taking it into their own hands, I should imagine that we will be able to view that, and certainly I would imagine that the court will be a lot more sympathetic to maybe considering applications of this nature on paper, given the new framework. But at the moment we're really early days, and we are yet to see anything sort of bed in properly in terms of that. So not at the moment, but I can envision it happening in the very near future.
Keep us posted.
Yes,
we just keep updating the blogs and the resources, and it does make such a difference to people. Anything co-parenting by far is our most read and sort of clicked on things on the website. So it just goes to show that that's really what people need and are looking for reassurance about. So yeah, much appreciated, Katie. So much, particularly as it's your evening as well. Don't
worry. Always help. And if there are any further sort of smaller issues like this that might need to be raised, and have a Q&A, because it is quite niche. It's not something that you'll be able to find a wealth of online resources about. So if there's anything like this that crops up in the future, do let me know, and we can arrange to have another one like this again. So
thank you. It's been genuinely really, really helpful. Really appreciate your time, and you were so quick with getting back to me when I requested it. So much appreciated for that.
All right. Thank you, Rachel. Have a nice rest of your evening, and I will speak to you soon.
Okay, take care. Bye.